all happened from quite a few years before that I've applied for the SAA for position as a flight attendant. It's been a dream for quite a few years, since basically school years already. I applied numerous times where I had the normal standard letter, sorry, your application has been unsuccessful. After which I continued applying and finally received a successful application.
It is illegal, which means it's unlawful, and it's also unethical for any person to be tested for HIV without their informed consent. 8
of us finally made it through to the medical tests, where we were flown to Joburg and subjected to medical tests, hearing, sight, blood pressure, all of those things. They also asked us if we would consent to a HIV test.
Especially in a working environment, no person, no employee or job applicant may be tested for HIV without their informed consent.
They just said to us, well, if you do not object against the HIV test, please sign this form.
An informed consent means that they receive pre- and post-test counselling.
I was asked to please come to the training manager's office, and there was a doctor, Dr. Peters, and he asked me if I know if I was HIV positive, which was the first time the results were pronounced to me, and I said to him no. He spent a maximum of 5 minutes with me and just told me there's no way I can have the job. He then handed me 4 or 5 pages of documentation on the SAA and on British Airways and Lufthansa that does similar testing and has similar policies, and gave a reasoning for the yellow fever vaccine being a high-risk situation.
In the case of A versus SAA and in the other cases against South African Airways, their main argument has been that all persons with HIV cannot receive a yellow fever inoculation because it would actually adversely affect their state of health. It would make them more sick or more ill. When the medical evidence, however, that we presented and the expert evidence, there is general consensus that not every HIV-positive person is unable to receive the yellow fever inoculation.
There was then the case against the correctional services that came up, and one of the HIV support groups that helped them, I contacted the official in that situation, and he said, well, if I would allow him, he would go further, do further investigation. He then referred me to the Legal Resources Centre, and the advocate or lawyer, William Kerfoot. We were set up an application. They told me that they would take the case, but that they wouldn't have great... At first, they weren't very optimistic about the case. I really believe that we were going to win the case in the Supreme Court. I didn't fight it as a labour case. I did address it as being unfairly discriminated against. We immediately made an appeal against the Supreme Court's decision and referred it to the Constitutional Court. The application went in, drafts were sent. In the beginning, yes, I did do it for myself. I wanted the position, and I felt that the only way I could get the position was if I had to put up the fight for it. And 8 years of trying was a hard enough fight for continuing it. So it only, when it reached the Constitutional Court, really sunk into me that this matter is quite more substantial than I thought.
We do have our first Constitutional Court case on the rights of employees in the working environment.
Practically took them 4 weeks to come out with the judgment, which was about 40 pages.
The appropriate relief is an order directing South African Airways to employ Mr. as a cabin attendant with effect from the date of this order.
So I was quite excited when I heard that I won the case, but I was quite unsure what was going to happen. The SAA has since offered me a position. I will accept it and I will take the position. I definitely want to fly, and I will make every effort to keep myself happy as well as the SAA happy with my employment.
The Constitutional Court judgment will have implications certainly for every type of employee in South Africa, more especially the mining industry. What it will do is it will show that HIV testing cannot be justified unless there is a rational connection to the inherent requirement of the job, and a position for cabin attendant is in fact a very exceptional category of employment because of the yellow fever inoculation. Firstly, about the Employment Equity Act, I must say that it's the most positive piece of labour legislation or employment legislation that has come out of South Africa, but also from around the world. It's the only positive piece of legislation that specifically protects the rights of people living with HIV and specifically protects against pre-employment HIV testing where it's not authorised by the Labour Court, and this is regarded as a world first. Secondly, it covers all employees and it covers all employers as well. So it would cover domestic workers, it would cover farm workers, and it would cover job applicants. It does not, however, extend to members of the South African National Defence Force, the National Intelligence Agency, and the Security Service. However, members of the South African National Defence Force, and we have many clients who are unfairly tested or wrongly tested and who are unfairly excluded from employment in the SANDF solely because of an HIV positive test result. Those type of cases can still be challenged using our constitution.